today. Okay, so The Honorable Justices of the Supreme Court, hear ye, hear ye. This court from recess now sitting.
Please be seated. Good morning and welcome. That's Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 10:30 docket.
10:30 a.m. docket for Wednesday, October 30th, 2024 consists of one case. Appeal number 126037. Case set for 20 minutes each side. POM of Kansas LLC versus Chris Kobach, Attorney General versus BHCMC LLC, Boyd Gaming, and Kansas Entertainment LLC, Shawnee County. Briefs both sides.
Good morning, Justices, and may it please the court, Tom Hamilton, attorney for Appellant POM of Kansas LLC. Also, my co-counsel, Mr. Ryan Kriegshauser, appears as well and will be with me at counsel table. With the court's consent, I would like to reserve 3 minutes of my time for rebuttal.
3 minutes is granted.
Thank you. President, ready for argument.
Thank you, counsel.
Please the court, Deputy Solicitor General Dwight Carswell appearing on behalf of state appellees, present and ready for argument.
Morning, and may it please the court. I'm Ryan Lair. I'm here on behalf of the interveners who are BHCMC LLC, Boyd Gaming, and Kansas Entertainment, present and ready for argument.
Thank you.
Your Honor, that concludes our 10:30 docket.
All right. Thank you, Mr. Shima. Counsel, please come forward in 126037. Mr. Hamel.
May it please the court, Tom Hamilton on behalf of Appellant POM of Kansas LLC. Just wanted to confirm, Madam Chief Justice, I've reserved 3 minutes of rebuttal time.
Yes, that's confirmed.
Thank you
Thank
again.
you.
And thank you again for the opportunity to present our arguments in this matter. This case is here today on direct appeal from the District Court of Shawnee County because of the constitutional issues presented on appeal. POM of Kansas LLC, or POM for short, is a Kansas subsidiary of Pace-O-Matic Inc., a national manufacturer of electronic skill games. A skill game is a game that is won or lost as a result of the player's skill, not by chance. Now, since many of us may not be very familiar with what exactly an electronic skill game is, for the court's reference, I think 2 examples are helpful. Dragon's Ascent is a game like electronic chess, which we refer to in our briefs, or also like pinball, a game that results possibly from some minor elements of skill, but certainly predominantly from the player's skill and not by chance. In 2020, we filed this lawsuit originally in the District Court of Douglas County. We sought 6 separate declaratory judgment counts in light of the uncertainty and insecurity that we had from law enforcement's treatment of our game in this state. Of those 6 counts, 3 remain, and we are appealing the dismissal of count 1, which was a declaration, which was a count seeking declaration that the Kansas Expanded Lottery Act, or KELA, does not apply to Dragon's Ascent. Count 4, seeking a declaration that 216403, the definition of gambling device, is unconstitutionally vague and ambiguous. And count 6, which was our originally filed count, seeking a declaration that our game is a game of skill. I'd like to start with
count 2 is not before us anymore.
That's correct, Justice Wall. Yes. On our constitutionally vague issue, again, that was count 4 of our second amended petition in Douglas County. That sought a declaration that the definition of chance, or as the result of chance, is constitutionally vague. As the court's aware, a statute or ordinance is constitutionally vague when it fails to convey a sufficiently definite warning to persons of common intelligence, or some cases use the language common understanding or practice.
Before you get too much into a merits analysis on that vagueness challenge, just let me walk you through a question I have on standing. I know that has not been raised by the parties below, but since the parties originally briefed this case, we've decided League One and the Stanek decision, both of which adopted a pre-enforcement standard, right? And under that, to apply under our Kansas standing framework. And that requires that, among other things, that you allege conduct affected with a constitutional interest. And it seems to me that maybe based on timing alone, that we don't have any allegations or evidence that could satisfy that element. But you certainly tell me where that logic might be wrong.
Thank you, Justice Wall. So just to be clear, you're referring to League of Women Voters, those decisions. And that was Justice Stiegel's written opinion, I believe, from last December. We addressed that in our reply brief and said, ironically, somewhat, we don't think you should follow this standard, but if you do, here's how we meet that test of credible threat of prosecution. And I think it relates more towards our count 6, our legality challenge.
I understand the argument on credible threat of prosecution, but the federal pre-enforcement test, as I understand it, that we have incorporated, you allege an intent to engage in a course of conduct arguably affected with a constitutional interest, that intended future conduct arguably prescribed by a statute, and then a risk of enforcement, a credible threat of enforcement. So it's really conduct affecting a constitutional interest, right? Because we don't have a First Amendment argument that, you know, the conduct's impairing that, don't have a due process. That's really where I'm wondering.
What our constitutional interest is.
Correct.
We would say it's for free commerce. It would be to conduct commerce unfettered. And certainly we didn't allege it because of timing, as you suggest, Justice, wasn't an issue until League of Women Voters. So we wouldn't have precisely said we have a constitutional interest when we pled our facts.
Right.
But certainly the facts that we have pled, we believe meet that constitutional interest, namely that we have a right to conduct business in the state of Kansas.
And that would just be like a right to contract, due process.
Due process,
interest.
contracts. There's some case law that escapes me right now, but just the right to conduct business in the state of Kansas unfettered by legal challenge. So, and I will return to League of Women Voters, I think, when we talk about count 6. But as it relates to count 1, our ambiguity challenge, our primary issue really with the district court's decision was their reliance on the Lee case. That was the only case that was cited by Judge Lutke. And I think it really points out precisely our issue with the vagueness of 216403 here. In Lee, that's a Kansas City, Kansas dog ownership ordinance. It said it was illegal to own 3 different types of dog, one of which was a pit bull. And it said right there in the ordinance on the challenge, dogs that are predominantly of these 3 types are illegal. Well, that's the exact language that we're missing here with 216403. The only word used is chance. Well, how much chance is chance? Is that doesn't inform game manufacturers. And I don't think that's the legislature's fault. I think when they passed that statute, it was thinking, well, this only applies to gambling devices. This only applies to games that are in a casino or bad actors that basically take a casino game, re-engineer it, and put it in a gas station. I want to be very clear. That is not our games. Our games are not slot machines, video poker, very much to the contrary. POM goes to extraordinary lengths to engineer our games so that they are the result of skill, like a skill-based video.
And just for a point of clarification, one of the things that can happen with your games is they can be changed and downloaded without anyone being aware changes have been made. What does that mean? Does it change the ability to use your skill to win, or what happens with those? What does it mean that you can, from a foreign site, download and manipulate the game, unaware, and that the consumer, me, is unaware of those changes that have been made? It seems to me that changes the skill aspect.
Forgive me, I didn't mean to interrupt you. Justice Rose, are you referring to the statement by the KRGC that they were able to manipulate the game with a?
No, I'm talking about you guys being able to download and manipulate from a site. Am I misreading that?
No, Your Honor. Once the software is uploaded into the game, it's uploaded. And we can do updates to the software for the game,
Okay.
but we can't manipulate it off-site now. It's not
Okay,
like a
thank you.
casino.
I needed a clarification.
Yeah, and that's a great question. It's not like a casino game. We're going to talk in a minute about why we're not an electronic gaming machine under the Lottery Act. The main reason we're not is because we're not connected to the
Okay,
casino
thank you.
system.
Another point of clarification too, just factually, because I'm a little unclear from the record. Did you do a rollout in 2019? Are the games in establishments in our state, and how long has that been the case?
The games have been here since 2019. They are in many jurisdictions. The injury and fact components, like, the necessary follow-up question is, well, how are you injured? If you're, there are jurisdictions we have not rolled it because of concerns by operate. So the chain of command basically works like this. POM is or Pace-O-Matic is in Atlanta, designs the game, manufactures the game, brings it to Kansas, where distributors then meet with operators, gas stations or restaurants, and they place the game. Some of those operators in 2019 were told by KABC agents, hey, this looks like a gambling device. Don't place it in. Until the KRGC blesses it or until the Attorney General blesses it, do not bring it into this establishment. And so there are locations where we've lost revenue, lost business because we didn't place the games there because of that threat. That's part of our credible threat.
Did they do that without playing the game, just based on what it looked like?
Again, Justice Wilson, we don't know because this was, we knew that there was an allegation from our operators that the KABC and others came in and said, this game is arguably illegal. We didn't even get to the discovery phase to be able to find out what did these agents say? What was their basis to say it? We believe it was from the letter that went out from the KRGC in August 2020 saying.
Did you sue KABC? Did you sue the ABC?
We did, Justice Biles, yes, and they entered into a stipulation, essentially saying, I'm going to paraphrase it, we're going to sit on the sidelines on this one and let the KRGC and the AG take the legal opinion because we're going to follow their directive anyway. So they entered into a stipulation with us after being sued, and it might be styled as Kansas Department of Revenue. But the stipulation was entered in 2020 after our lawsuit was filed. So just very briefly on the vagueness piece. What we don't disagree that if the court were to look at the Three Kings versus 6 2011 case and apply that standard of predominance, we don't oppose that. So then why did we appeal it? Well, we appealed it because we don't have any precedent that's binding on the district courts of Kansas to interpret chance. If we had just said, well, we'll leave that alone, we'll leave Judge Lukey's decision alone, that would not have any precedential value to protect us moving forward as to how to interpret chance under 216403. Let me turn, because my time is short, to the legality and getting back to Justice Wall's question about credible threat of prosecution. There's two facts, excuse me, two facts that not only were they alleged, but we really don't believe that they were considered by Judge Huff in her original order dismissing these counts as to the KRGC. These were alleged in our second amended petition. They were attached as exhibits by way of affidavit and the letter itself to our opposition to the motion to dismiss. Here's what the August 10th, 2020 letter says. It's from the executive director, Don Brownlee of the KRGC, and he sends it to the Kansas Sheriff's Associations with the hope, quote, the hope that you will disseminate this information to association members. He also copies the then president of the Kansas District Attorneys Association and others. And he says, number one, we've played the game. It contains too many non-skill features to allow mastery of the game. And our position is that's just the artfully worded way of saying this is an illegal game. We're not going to give POM an opinion, but we will give an opinion to law enforcement that we think there's too many non-skill elements, too many chance elements for this game to be legal. He then goes on to say, we've played the game. We can also manipulate it to make it non-skill. And that was another thing that was stated in the letter. And then finally, he says, as with all suspected illegal gambling devices, really letting law enforcement know we question the legality of this game. We don't think it's legal, but we're not going to give an opinion to POM right now. The one case to the League of Women Voters jurisprudence, Your Honor, because it hasn't been borne out a ton in Kansas since the decision last December. A case that we think is if not directly on all fours, it's close to it, is that New Hampshire Lottery Commission versus Rosen case. It's a First Circuit 2021 case. In that case, the DOJ had always prosecuted the Wire Act against illegal sports gambling back when sports gambling was illegal. I guess it still is some places. And they sent out a letter opinion saying, hey, lotteries, we think that it might also be illegal what you're doing, selling lottery tickets online. The Lottery Commission's panicked, thinking we've done this for decades. So they file a deck action just like we did, not based on an allegation we're going to come prosecute you, or not based on a prosecution itself, but on concern that under this new letter opinion, we're going to be, prosecuted criminally in federal court. The day that the DOJ answers their petition for declaratory judgment, they issue a new memorandum saying, well, we're not sure. We might follow this 2018 letter opinion. We might not. And the First Circuit rightly said that type of gamesmanship is number one, it's a credible threat of prosecution. And the only way that you can undo that is to disclaim prosecution, is some statement to say, we're now going to undo the credible threat that you've placed the Lottery Commission under by disclaiming that prosecution. The other fact, the letter from 2020 is one fact. The other fact is we allege, in I think it's paragraph 158 of our Second Amendment petition, KABC agents went to third parties and said, your game is likely illegal. Don't place the game. That's an injury in fact under the two-part traditional test. Neither one of these allegations appears anywhere in Judge Huff's 50-some paragraph opinion. And then when Judge Lukey looks at the issue, and I understand the confusion because the case gets transferred and he's trying to parse out what was ruled on and what was not. There's no order from Judge Huff dismissing the Attorney General on any count. The Attorney General, yes, Justice.
Let me interrupt you. I mean, because I had a note to myself that the Department of Revenue wasn't a defendant. And then when you said they were, then I went back and looked at the Douglas County order in paragraph 20. It makes reference that they used to be a defendant and then they were dismissed on November 2nd, 2020. Assume with me I'm having trouble accepting the notion that you have standing to raise these questions in a court of law. Just assume that. Do I get to look at the ABC allegations when they've been dismissed as a defendant, as opposed to a stipulation where they've agreed to follow whatever the court wants to do, and they're just along for the ride? I used to do those kinds of things. I never did this. And so I'm now hung up on whether those allegations are in play for standing purposes when you don't have a defendant who did it.
I think, Justice Biles, what I would say is in that same order that you're referencing in paragraph 44, Judge Huff makes the finding that the KRGC and the District Attorney of Douglas County are going to follow the AG. But they also retain their own prosecutorial judgment to do that. So I think even though the KABC was dismissed out, the allegations that they're potentially being directed by the KRGC or being directed by the AG
That's all fine, but if the AG doesn't want to pursue this, then you still don't have any ability to be here.
Possibly not on that fact, Your Honor, but certainly on the August 2020 letter would give us standing, because that's the KRGC in its authority telling law enforcement throughout Kansas your game is illegal.
But does that actually, and I guess I'm wanting to compare it to the First Circuit decision that you cited. The letter, though, it does conclude that they're not taking an opinion. I understand what you're saying, that, okay, maybe if you might be able to read between the lines about what some of the folks testing the game, what their impressions were, but there's not an official opinion saying this is illegal like you had in the First Circuit. And then in the First Circuit, it gets backtracked a little bit. I just interested to see your response to somebody that says that would distinguish that authority. that you need an affirmative disavowalment of prosecution.
Not to use a trite axiom, Justice Wall, but I think that's a distinction without a difference. There wasn't a finding in New Hampshire Lottery Commission, the First Circuit case, that that the credible threat of prosecution was caused because it was an official letter. It was because of the statements made in the letter by the DOJ that we think that you're going to be in violation of the Wire Act. Same thing in our letter here. We think that this game has too many chance elements. And anecdotally, that's what has existed over the last 5 years, is confusion amongst law enforcement about the status of our game.
I have a couple questions. I know you're out of time, but I'll try to make this quick. And I want to ask, they're kind of big picture questions, but I'm trying to get a more precise understanding of what your constitutional interest is. So you've clearly argued that your conduct is affected with a constitutional interest. And you've identified the right to contract, right to make a living, those kinds of ideas. If that's the case, why wasn't part of your lawsuit that if this is determined to be a game of chance, the Lottery Act is unconstitutional? Because it impinges upon your constitutional interest.
Well, our original lawsuit, Justice Stiegel, was just to say our game is legal vis-a-vis the gambling statute, not even the lottery.
Okay, maybe I shouldn't have specified the Lottery Act, but the enforcement against our game would be unconstitutional under whatever legal scheme.
Possibly because, as Justice Wall alluded to, we weren't really thinking in a credible threat of prosecution framework until League of Women Voters came down. We were more just thinking under the old test of, we have a protected interest and there's an injury, in fact, the causal connection, like under.
But I'm trying to, again, clarify what your protected interest is. And I'll cut straight to the chase. Is it your position that your protected interest is to sell games of skill? Or is it that your protected interest is to sell whatever game you want, chance or skill?
Oh, certainly not chance. Chance would be.
Well, why not? That's what's curious to me. If you have a constitutional interest that is rooted in a freedom of contract and right to make a living, why wouldn't that interest also cover games of chance? And that doesn't answer the question of whether the state can prescribe it, because then you get into standards of review and the state's interest and so on.
Well, I don't want to make Mr. Lair's argument for him, but I think the casinos would say we have an express monopoly over any right to operate a chance game.
That doesn't answer the question of whether or not your constitutional rights are being impinged or infringed upon. I mean, it might still be lawful, but again, I'll just say it strikes me as a manufactured claim to say that my constitutional interest is limited to selling games of skill. That doesn't make any sense to me.
But that's the only games, Your Honor, that we manufacture. We're not in the business as, you know.
But those games could be found to be games of chance. Would you then relinquish your constitutional interest to sell those games?
I don't think we've ever thought about or completed that analysis,
Okay.
really, because our games really are just, we've always operated under the
You
assumption.
haven't gotten to that step because you're fighting on the first grounds, which is we're not a game of chance.
That's correct. In every jurisdiction where we encounter these arguments, it's essentially to protect our right to operate skill.
And has there been any fact development on the skill chance aspect of what's before us and what's before the district court? There really hasn't been, has there? I mean, we hear your statement, we hear the state's statements, but there really is no facts that we can utilize to kind of understand that in terms of your vagueness claim.
We did not even get the opportunity to do that,
Okay.
Justice Rosen. We were cut off by the motion to dismiss as being granted. Thank you.
Mr. Carswell?
It pleases the court, Deputy Solicitor General Dwight Carswell appearing on behalf of state appellees. The appellees are going to be splitting their time, 15 minutes for state appellees and 5 minutes for interveners. The district court correctly held that POM failed to present a justiciable controversy with respect to state appellees with regards to its request for declaratory judgment as to whether Dragons is a game of skill or a game of chance. They believe that it's legal. The state appellees have taken no position on that. Therefore, there's no dispute. And so they lack standing to sue the state appellees. As to the Attorney General has submitted an affidavit.
Is the primary foundation of the state's position on that there is no imminent threat of prosecution?
I think it's twofold. I mean, one, there's just no dispute because we don't disagree with them on anything. But then secondly, yes, there is no credible or imminent threat of prosecution.
Yeah, so couch it in terms of our league
Yes.
factors. You're not arguing that their activities are not affected with a constitutional interest?
We are not. I don't think the credible threat of prosecution needs to actually be limited to whether there's a constitutional interest or not. I think
But those are the pre-enforcement factors that are outlined in league.
I think that's one situation where that arises, but I don't think the credible threat of prosecution standard needs to be limited. That I think anytime someone's saying, well, I have an injury because someone may prosecute me, understanding you have to have a credible, cognizable injury. In order to have that, there needs to be an imminent. And
so you think standing in Kansas law is actually broader than what's outlined in league?
I think that league test arises specifically the constitutional injury when you're bringing a claim that a statute violates the Constitution, which would be here claim 6. But with respect to claim 1, where they're not claiming a constitutional injury, you would still need to prove a credible threat of prosecution.
But when they are alleging, when they're challenging the constitutionality of the statute and we're applying this 3-part test, you're suggesting that we can just dispose of conduct affected with a constitutional interest? I mean, I understand your argument that maybe that factor exists because it just happens to be the circumstance that in most of these cases, they're First Amendment cases, so that just happens to be present. But at least in our research, my research, I found one offshoot of a case that viewed that from that perspective and not as an essential element of standing for a pre-enforcement challenge. And I guess I want to clarify what the state's position is on that. When you are challenging the constitutionality of the statute, do you need to show conduct affected with a constitutional interest?
When the claim itself is that this is unconstitutional, yes. And we don't contest that with respect to count 6.
But you're saying that just saying that it's just the challenge being constitutional alone satisfies the challenge, not that. So any vagueness challenge, whether or not the conduct in question of the defendant implicates protected activity.
There might be a gap there in some cases, but here they're claiming at least that their conduct is. We haven't contested again their standing with respect to count 6, just with respect to count 1 and then. Or excuse me, I'm not going to set an account. Sorry.
Yeah, you're not challenging it.
Count
4, but we need to have that as a court, whether you guys agree on it or not. And I guess it seems to me, why would this federal test include that as an element if every constitutional challenge automatically meets that requirement? I guess it just seems to me that it means something more, that it's not just because you're challenging the constitutionality of the statute. It's because, like, for example, in league, there's allegations that the existence of this unconstitutional statute is implicating a party's constitutional interests, like the right to free speech, or maybe it's the freedom to contract, whatever, but that is an element. Otherwise, if just a constitutional challenge was enough, that would sort of render that element moot in the 3-part reinforcement challenge. Does my question make sense?
Yeah, I think in the vagueness context, they're arguing, I don't know what their particular, because again, there was no standing argument with respect to count 4.
Right.
But I think their argument would be that whether it's limited to games of skill or games more broadly, that was the discussion there. They're making some kind of argument that they have.
Well, yeah, and let me follow up with ask maybe the same questions just as well, a little differently. I'm having a hard time envisioning any other kind of pre-enforcement challenge other than a constitutional challenge. In other words, at the heart of these pre-enforcement actions is the claim, if you enforce this law against me, you're violating my constitutional rights.
Well,
What other kind of pre-enforcement challenges?
Well, that's count 6 is what they're bringing here, which, just to be clear, we are challenging their standing with regard to that. And that's not claiming that the statute's unconstitutional. It's saying that this statute does not apply to us. It's
Right,
statutory.
but there's a chicken and egg issue here. Of course, they're saying it doesn't apply to us. That's what the plaintiffs in the league wanted their final outcome to be as well. But the other half of that coin is, and if it does apply to us, it's unconstitutional because it infringes our constitutional rights.
But
right?
the underlying claim in League of Women Voters was the constitutional claim. And they actually, in the League of Women Voters case, the plaintiffs thought it applied to them.
I understand that, but
So they're,
are you suggesting that we allow pre-enforcement challenges simply so a party that's not affected with any constitutional interest can get an advisory opinion about whether their conduct falls within the statute or not?
no, I'm the opposite. I'm saying you shouldn't allow unless there's a credible threat of prosecution. I'm just saying that standard applies. You need to show a credible threat of prosecution regardless of whether there's a constitutional interest involved. So when you're bringing a statutory claim, like in count 6, even when there's no constitutional claim, you still need to show a credible threat of prosecution. And they haven't done that here because this game has been in Kansas since 2019, and state appellees in those many years have not seized the game, have not prosecuted POM. So there's no credible threat of prosecution, certainly nothing that's imminent. At best, that threat is speculative, which in League of Women Voters, you said is not enough. Therefore, it's not a credible threat, regardless of whether there's a constitutional interest.
But I don't know, what do you make of the argument, though, that you've kind of kept them in this purgatory by sending mixed messages? And I guess they would point to the KRGC letter that sort of sends a signal, or one could read that letter as sending a signal that, hey, we think there are potential problems with this game, but we're not going to take a formal opinion. I mean, is that just too bad? Our law that just doesn't pass the threshold. But it seems like, can you just keep a party in this sort of no man's or no person's territory for, ever?
Well, I don't think it is mixed messages. I think at the end of the day, you read the letter, it says we have no opinion on this. And it says even if we had formed an opinion, things change over time. The source code can change. So even if we had provided an opinion on whether the game that was provided to us was legal or not, what's actually being put out there in bars or wherever could be a different game essentially, and therefore we can't provide an opinion on this.
And what about the KABC agents, or the allegations that those agents were telling folks they're not a party anymore to this action? But is that still a relevant allegation to the risk of prosecution?
At most, it would provide standing with respect to KABC, but again, they've been dismissed from the case. It doesn't provide, there's no causation with respect to the state appellees. They were not the ones who, again, the second prong of the standing analysis is the causation, and you don't have that causation with respect to state appellees here. And the fact that I alluded to that the game can change, that's particularly important, as this court was talking about in the Witchner v. City of Atchison case. That wasn't a standing case, but the court still said a declaratory judgment would not be appropriate there precisely for that reason, because if there was a declaratory judgment as to the legality of a game, how that game actually played out in the field could be different than that. And so the court said, well, a declaratory judgment could actually create more confusion than clarity. So that standing is important, so you have concrete facts rather than just this opinion that's separated from actual reality.
Do you read that decision as a larger indictment of the use of the Declaratory Judgment Act as a means to deter against criminal prosecution? Is there a larger takeaway from that decision? And if so, can you kind of connect those dots for me?
I think so. And there's that Court of Appeals opinion, that Theismann case, where that's how they read it. And I think that's correct. It's saying, in general, when there's the declaratory judgment act should not be used to bring kind of pre-enforcement decisions on whether a particular factual situation would violate criminal laws. And again, unless there is a credible and imminent threat of prosecution, I think those standards all go together, where you actually have, concrete facts, and it's not just some hypothetical speculative situation that's down the line. It's also important to have an actual dispute in addition to the credible threat of prosecution. I don't know that those are necessarily two different things, but without an actual dispute, there's no real adversarial process to help the district court make an informed decision. Here, the question is whether this is a game of skill or a game of chance. POM is saying it's a game of skill, but without the state appellees taking the opposite position, there's no one to argue the other side. Yes, the intervener.
That was kind of my point of my last question to council. There really has been no fact development on that question.
Not in this case.
Not in this case, right?
There's a separate case where the interveners have brought in Shawnee County District Court where the state appellees are not party to that case, but it's going on where they're fighting that question.
Okay.
There, but in this case, the interveners were only allowed to intervene as to the constitutional claims, not as to count 6. And so there is no party as to count 6 to take that opposite side. And without that adversarial process, which is why we have that standing requirement as part of the constitutional case and controversy requirement. To address the vagueness challenge in the time I have left, the statute uses the phrase a result of chance. The term chance is well understood. That's this chance versus skill is the common law dichotomy that's always been used for gambling throughout the country, going back for a long time. It's even part of the Kansas Constitution, our lottery definition. Result is not, incapable of being understood. Maybe it could be susceptible to multiple interpretations, but lots of times statutes could be interpreted one way or the other. Here it seems like the best interpretation based on the Court of Appeals Three Kings case and this court's decision in games management is it's probably the predominant factor test. Maybe there's some other tests. You don't need to decide that today. But just again, this court said in the Boatwright case that the fact that a statute could be interpreted multiple ways doesn't render it vague. Ultimately, if there's a dispute over that, that's something the court would need to settle. If it's ultimately ambiguous, the rule of lenity could come into play. So just the fact that there are multiple interpretations doesn't make it vague. Finally, with respect to the Keela case, I'll just rest on our briefs there. I don't think there's much to be said unless you have any questions on that or anything else.
What about the for that First Circuit opinion that that POM relies on to suggest that you need to affirmatively disavow when there's potential ambiguity about the intention of law enforcement?
I think that case is different because there the DOJ had put out an opinion letter saying the Wire Act applies to non-sports gambling. And the First Circuit said, well, they haven't ever disavowed that opinion itself. They just said, well, we may not enforce it with respect to state lotteries and their vendors, but we're only going to even say that for a certain limited period of time.
The opinion remained.
The opinion remained. And so there was actually even a dispute as to whether DOJ was saying, yes, it does apply at least to non-sports gambling. And the issue in that case was whether it did or not. Here, the state appellees have not said that this is a game of chance at all. So there's been no initial claim that they've backtracked from or tried to say, well, we're not going to prosecute you for a certain amount of time. And the other cases, POM cites on the affirmative disavowal, a lot of times those come up in cases where someone's saying, well, I want to violate the statute or I want to do what the statute prohibits and I'm claiming the statute's unconstitutional. In those situations, there is obviously would be a credible threat of prosecution because they're claiming I'm going to do what or could be at least under the circumstances, do what's illegal. And so they could expect to be prosecuted. That's very different than here where they're not challenging with respect to count 6, the constitutionality of the statute. It's just a question about whether the statute applies or not. And state appellees have taken no position on that. So,
I just want to clarify. So on count 4, which is the constitutional challenge, right? You are not opposing standing. You agree they're standing.
That's correct. We not.
And then on count 1 and count 6, you're disputing. Okay.
That's correct. Yes.
I guess I don't understand how if there's not a likelihood of prosecution, that doesn't get you to the same outcome on count 4, though.
Yeah. Okay. With count 4, at least there is a dispute in that they think the act is illegal. We think or unconstitutional. We think it's constitutional. And also there is, I think, possibly an injury in the sense of if you can't tell whether it's a game of skill or game of chance, if the statute is just so ambiguous that you can't conform your conduct to the statute, that could, I think, be an injury. So that's why we didn't contest that. Unless there are any further questions, we just ask that you affirm the district courts. Thank you.
May it please the court, I'm Ryan Lair again on behalf of the interveners. I suppose I'm just here to gild the lily a little bit. I don't really necessarily want to repeat everything Mr. Carswell said, and our arguments are all in our brief. So I'm more or less just here to answer any questions if the court would have any questions of my client, the interveners who are the casinos in this case. I do want to point one thing out, though, is with regard to the idea of whether chance is an ambiguous term without definition. The POM in their own petition, they claim that Dragon's Ascent contains no chance elements. And throughout their initial pleading, they use the word chance. So if it's ambiguous, how do they know? And that's, you know, that's what I would say to that regard. So if there are no questions, I'll suppose I will waive our arguments.
Guess I want to be,
Yeah.
as I understand your position with your other lawsuit. You've got a contractual right to be able to do what you do. And so there really would be no dispute as far as standing goes or actual controversy for you to come in and say that POM should not be able to engage in the business it is because it infringes upon the contractual right you have with the state of Kansas, right?
Yeah.
That clear enough?
I believe that's correct. And just as for clarification, at the time of briefing, it was a Wyandotte County action. That action has since been dismissed and it's been refiled in Shawnee, and it brings 3 counts. It's a tortious interference with business expectancies, breach of Kansas common law, unfair business practices. And we did bring a count of declaratory judgment that Dragon's Ascent is a game of chance. But yeah.
And what's the posture of that case in Shawnee County?
It was filed, I believe, December 31st of 2023. It just survived a motion to dismiss, and discovery is getting ready to kick off.
So discovery hasn't taken place?
No, there is an agreement between opposing counsel and us where discovery that was conducted in the Wyandotte case will be able to be reused. So it's a little ahead of the game, but yeah.
Okay.
Any other questions?
Well, thank you.
Thank you, Mr. Lavin. Mr. Hamilton, you reserve 3 minutes.
Thank you, Madam Chief Justice. I want to first address Justice Wall and Justice Stiegel. You both had asked about the constitutionally protected right. I think in addition to just the general right to contract, we certainly have our due process right to understand, well, what does this law mean if we don't know what it means, if there's not a test that a person of common intelligence can understand, how does that protect our due process right? We wouldn't know if we were violating the law or not. So I think that would be an additional constitutional right that would be protected. And again, as it relates to the state parties, we feel like strange credulity for them to say we don't, just because they don't take a position in their briefs now and say, well, we don't have a controversy with them. Our position is that the August 10th, 2020 letter is most certainly a position, and most certainly says to the law enforcement community, this is a game with too many non-skill features. That's what creates they have taken a position. It's not that the facts haven't been borne out versus chance and skill. They've evaluated the game, and now they're informing the law enforcement community. This is not a game of skill. This is a game with too many non-skill features. And that's the precise language that had they sent out a letter and just said, you know what, we've looked at the game, we're not really sure, proceed accordingly based on your best judgment, whatever they were going to say, that certainly wouldn't be a credible threat of prosecution. This is, especially when it's concluded with, as with all suspected illegal gambling devices. And you say right there in their letter, we suspect this is an illegal gambling device. Again, no cases are directly on all fours, but it's very, very close to the First Circuit opinion that we cited to. On our Keela issue, I also just want to reference for the court, since it's not in our record, the case that Mr. Laird just referred to is in Shawnee County. It's case number SN 2023 CV 000-655. And in that case, we believe that's what makes our Keela claim, count one, not moot. It was dismissed on mootness. The reason we believe it's not moot now is because after we briefed this appeal, they refiled the same action. And the thrust of their lawsuit is Keela has two definitions for electronic devices. One is a gray machine, which means it's healthy. Our definition no longer exists because in 2011, the Dismeyer case made it ruled that it was unconstitutionally vague. So we can't be that. The only other electronic device in the Keela statute is an electronic gaming machine, a machine that's connected to the central lottery computer system. They're saying we violate that. That's our entire argument for standing, or excuse me, for non-mootness on count one on the Keela claim. So I just wanted to clarify that. And with that, if there are any other questions?
That doesn't suggest that there's a risk of prosecution just because a competitor or arguably a competitor asserts that claim, right?
That's correct, Justin. We didn't file that on, we're not relying on a credible threat of prosecution standard there, merely that we don't feel if they're going to allege that you're violating Keela, we should be able to have a finding with the state parties involved where they would be bound by that so that we don't have to go and litigate that 4 separate times against the 4 different casinos. Thank you. And we would ask, obviously, that you reverse the district court's dismissal of our claims. Thank you.
Thank you. Thank you to all counsel in this matter. We appreciate your arguments today. The court will now take this matter under advisement. Court is in recess until 9 a.m. tomorrow morning.
All right.